Hello, I hope you guys are doing well. We are moving into healthcare laws. We are going to be doing, well, it's called two different things. So stop. On the 13th edition, it's called Medicine and Law, and it's chapter 6. On the 14th edition, it's called Healthcare Laws, and it's chapter 4. So I want to remind you that I'm kind of trying to meld two books together, and it's just a little bit different in some areas. But we're actually just going to be talking about laws. So I want to tell you that for homework today, you're going to have NCCT laws, the ones that are going to be on your, it's healthcare laws, but these are the ones that are going to be on your NCCT test. So I want to make sure that you know these, and so you will be tested on them. It will be next week before you're tested on them. But you will be tested because you have to know those laws. There's lots of questions on your certification exam about those laws. Also, I want to say that we have a couple of things coming up. Miss Maria's last day will be the 5th of October. So that is going to be next Monday. So congratulations, Miss Maria. It's not quite time yet, but it's coming up. All right, so here is our lecture. We're going to share the screen as usual so we can do our PowerPoint slide show. So medicine and law. Criminal law governs violations of the punishable as offenses agent against, oh my goodness, let me start again. Okay, deep breath. Criminal law governs violations of the punishable as offenses against the state or the federal government. Offenses involve the welfare and safety of the public as a whole. Medical assistants can be prosecuted for criminal acts such as assault and battery, fraud, and abuse. There's 3 basic categories of criminal offenses: misdemeanors, felonies, and treason. To ensure fair treatment under the law, all individuals are entitled to due process. Okay, misdemeanors are minor crimes such as petty theft, disturbing the peace, simple assault, and simple battery. Felonies are major crimes: first-degree murder, second-degree murder, and third-degree murder. Civil law acts that are not criminal. These acts that are not criminal, they are civil law: tort law, contract law, administrative law. What is tort law? Harmful by the wrongful acts of others. Examples of these wrongful acts are defamation of character, slander, libel, and malpractice, medical. Contract law. A contract is an agreement that creates an obligation. This touches our daily lives without us even realizing it. When you sign a rent agreement and then decide to move, you're still bound by law to pay your monetary obligations. A contract can be oral. For example, when you make an appointment, you are agreeing to be there at a certain time. Did you guys ever realize that that's a verbal contract? What is a legal contract? A contract is a legal, enforceable agreement between 2 or more parties. It can be oral or written. A contract is essentially a set of promises. Typically, each party promises to do something for the other in exchange for a benefit. Required characteristics. To constitute a legal contract, an agreement must have all of the 5 following characteristics. Legal purpose. The contract must have a legal purpose to be enforceable. For example, Steve hires Paul to kill Susan. Steve drafts an agreement outlining Paul's responsibilities, namely to acquire a gun and shoot Susan in the head. The agreement also specifies the amount Steve will pay Paul once Susan is dead. A contract of murder for hire is illegal if Paul fails to fulfill his obligations under the agreement. Steve will have no recourse against Paul. The agreement Steve has drafted is unenforceable. Okay, so I know that that's a bit dramatic, but that's just an example. If it's not legal, you can't force a contract. Has to be legal. Mutual agreement. All parties to the contract must have reached a meeting of the minds. This is, one party must have extended an offer to which the other parties have agreed. For example, Jim signs a contract with Tom's tree trimming. The contract outlines the scope of the work Tom will perform on Jim's property. Jim and Tom have a mutual agreement regarding the work that will be done. Consideration. Each party to the contract must agree to give up something of value in exchange for a benefit. For example, you hire an independent contractor to repave your driveway. You and the paving contractor sign an agreement in which you promise to pay a sum of money in exchange for the paving work. Both you and the contractor have agreed to give up something of value. You have agreed to pay money, and the contractor has agreed to perform the paving work. Competent parties. The parties to the contract must be competent. That is, they must be of sound mind, of legal age, and unencumbered by drugs or alcohol. If you enter into a contract with a minor or insane person, the contract will not be enforced. Genuine assent. All parties must engage in the agreement freely. A contract may not be enforced if mistakes have been made by one or more parties. Likewise, a contract may be voided if one party has committed fraud or exerted undue influence over another. For example, you sign a contract which you agree to sell your house to your next door neighbor for $1. When you signed the contract, your neighbor was pointing a gun at your head. Clearly, you made the agreement under duress, so the contract is not valid. In short, you must have agreement, it must be legal, competent, and consideration must be involved. Medical professional liability lawsuit. Every medical provider faces this at least once in his career. Medical assistant may be involved. Please always be truthful if faced with this situation. Be especially careful to a true, complete statement to the representing attorney. Interrogatories. A list of questions from each party to the other in the lawsuit. The answers to these questions must be given within a specified time, and answers are considered under oath. Depositions. An oral testimony of a party or witness in a civil or criminal proceeding taken before a trial. If you are called to be deposed in a case, then the attorney will prepare you for questions from opposing attorneys and will be present during the process. Subpoenas is a document issued by a court that requires a person to be present at a specified time and place to testify as a witness in a lawsuit, either in court proceeding or in a deposition. What is the meaning of subpoena ducis tectum? Well, 13th edition is on page 71 through 73, and I'm not sure on the 14th edition. So I'm going to leave you guys to find that yourselves. I know that you can find that without any issue. Medical negligence.
Medical negligence. Visualized. Medical liability is the physician mistake, like inaccurate and incomplete diagnosis or treatment, which cause the patient injury or death. The affected patient must prove two things, in order to show that he was harmed. First, that the doctor breached his duty of care, by committing an error, whether by ignorance or negligence. Second, that the medical negligence harmed the patient health, enjoyment of life, and money. Which means that without damage, there is no basis for a claim, regardless of the doctor negligence. On the other hand, the physician has to observe the following duties. First, to follow the standard medical rules and procedures. Second, to document the patient health condition, and his family medical history, before diagnosing and treating him. Third, prescribe to the patient the medicine dosage and side effects, in addition to monitoring the treatment progress and complications. Fourth, to inform the patient of the nature of his illness, unless the patient interest requires the opposite. On the other side, a doctor is restricted from undertaking the following acts: treating the patient without examining him, and without the patient approval in non-emergency cases. Carrying out any act of birth control, or sterilization, unless there is a serious threat to the woman's health in case of pregnancy. The fixing of prosthetic on the patient body. Examining a female patient clinically, without the presence of a third person. Adopting artificial insemination, unless from the spouse. Doing unauthorized clinical research on people. In addition, the doctor is prohibited from doing the following acts: cloning human beings. Use an illegal treatment method. Disclose the patient confidential information. Evacuate the patient from the hospital, stop his treatment, or helping to end the patient life. And lastly, the doctor is prohibited from doing anything that would lead to an abortion, except when the early pregnancy is dangerous to the woman's life, or if the fetus is suffering from a serious malformation. But in both cases, the abortion is only allowed before 120 days of pregnancy. After we reviewed what is allowed and what is not, let's see now, what if the doctor is accused of negligence? The law assigned the Supreme Committee of Medical Liability to investigate the causes and relationship between the doctor mistake and the patient harm. However, the doctor may not be arrested during the committee investigation, but he might face criminal and civil charges. Unless the doctor proves that the damage was caused by the patient, or due to an external reason, beyond the doctor control.
Alright, I hope you learned a lot through that. Oops. It's going off again. Okay. The 4 Ds of negligence: duty, dereliction, direct cause, and damages. So this is an assignment for you. You need to define each of these 4 Ds and submit their definitions, please. Types of damages: nominal damages, punitive damages, competency damages, general, special. I need you to define each of those and explain them. I know I have page 74 here, but I don't know that that's 74 in the 14th edition. I know it's in the 15th, in the 4th. It's page 74 in the 13th, and I'm not sure in the 14th. What are risk management practices? A combination of different approaches in the healthcare facility that reduces the likelihood that either an individual healthcare professional or healthcare facility will be sued. Some of these approaches may include adequately trained staff, open communication among staff regarding potential risks, policies on expired scripts and refills preventing medical abuse, strict policy on test results, tracking missed appointments, communication issues with patients, misinterpretation of the doctor's orders, Safety in the facility for patients and staff, proper lighting, grab bars, exit signs, and safe exterior. Documentation procedures are strictly adhered to. Liability, malpractice, and personal injury insurances. Individual providers in healthcare facilities typically purchase several different types of insurance. They may be involved in either researching or renewing these insurance policies for your employer. Examples of insurance are as follows: liability insurance, medical malpractice insurance, personal injury insurance. Let's define informed consent. Voluntary agreement, usually written, patient under details for treatment and procedures. Informed consent is voluntary agreement, usually written. Patient understands details for treatment and procedures. Apparently, I left off part of the understand. Sorry about that, guys. But that's what informed consent is. The patient is informed and agrees voluntarily. What is implied consent? A provider must have consent to treat a patient, even though this consent is usually implied by the patient's appearance. The implied consent is sufficient for common procedures. What is expressed consent? It is known as general consent. Is consent given after a patient is asked a question such as, "Can I gather your health history?" Then the patient replies, "Yes, you have been given consent to perform that procedure." Informed consent is defined as, is a must when major procedures are involved. Physician can be charged with battery if not given. Must be gotten in a case of procedures have high risk involved. It is the provider's responsibility to make sure the patient is aware and informed, not the AMAs or the MAs. The patient will decide if he or she will sign the consent and move forward. AMA standard for informed consent. Patient's diagnosis if known. Nature and purpose of the procedure or treatment. Risk benefits of the treatment or procedure. Alternatives. Risk benefits of the alternative and risk benefits of not undergoing treatment or procedure. This is your standard for informed consent. Statute of limitations is a law which sets the maximum period which one can wait before filing a lawsuit depending on the type of case or claim. The periods vary state by state and by type of claim. Federal statutes set the limitations for federal lawsuits. If the lawsuit or claim is not filed before the statutory deadline, the right to sue or make a claim is lost forever. Confidentiality. Okay, guys, this is so important in healthcare. Confidentiality is keeping a confidence between the client and the practitioner, which is as important. Oh, I'm sorry, let me read it again. Confidentiality is keeping a confidence between the client and the practitioner, which is an important part of good care practice. What is compliance reporting? Compliance reporting is an organization's adherence to laws, regulations, and policies applicable to its operations. Violations may result in punitive action, including imposition of fines and/or criminal charges. Clinicians have a responsibility to adhere not only to their professionals' clinical and ethical standards, but all applicable laws, regulations, and policies. Medical assistance is involved in the responsibility of compliance reporting, such as births and deaths, sexually transmitted diseases, and child abuse. What is the Patient's Determination Act? I want to go back. Know these, they're on the NCCT. So now I'm going to move forward. Sorry about that. What is the Patient Self-Determination Act? The Patient's Self-Determination Act is a federal law and compliance is mandatory. It is the purpose of this act to ensure that a patient's right to self-determination in healthcare decisions can be communicated and protected. Through advanced directives, the living will, and the durable power of attorney. Guys, know what an advanced directive is, what a living will is, and what the durable power of attorney is. The right to accept or reject medical or surgical treatment is available to adults while competent, so that in the event of such adults become incompetent to make decisions, they would be more easily continue to control decisions affecting their health care. Without advanced directives and the proper adherence to such directives, former President Richard Nixon and former First Lady Jacqueline Kennedy Onassis might still be alive today in persistent vegetative states. This article examines the history of the act, its importance to each individual, and the clinical, ethical, and legal issues and the role of healthcare professionals in effectively implementing and ensuring compliance of the PSDA. So I thought it was really interesting about Nixon and Lady Jacqueline Kennedy Onassis, that they would be in vegetative states if not for their living will or advanced directives. Okay, so what is an advanced directive? An advanced health care directive or advanced directive is a kind of legal document that tells the doctor your wishes about your health care. Advanced directives can be general with very few directions about your care. The directive may just name a substitute person or proxy to make these decisions for you if you are unable to do so, or it may include instructions for chosen proxy. If a person becomes incapacitated, perhaps because of mental illness like dementia, he can no longer make healthcare decisions for himself as he once did. If he creates a durable medical power of attorney, he named an agent to make his healthcare decisions if and when he becomes unable to do so, and this agent is responsible for following his wishes closely and acting in his best interests. Okay, I am just going to leave the Uniform Anatomical Gift Act here. Please pause it and read it. We're going to discuss Patient's Bill of Rights. The AHA Patient Bill of Rights, the American Health Association. These rights can be exercised on the patient's behalf by a designated surrogate or proxy decision maker if the patient lacks decision-making capacity, is legally incompetent, or is a minor. So.
Hello and welcome in service hours. Test is completed. If you have any questions, contact the office. Thank you.
We need to start.
The purpose of this in-service is to help you understand the rights our clients have while they receive services from Osborne Home Care. Key areas we'll be learning about are accessibility and education, interacting with clients, complaints and grievances, and responsibilities, both ours and the client's. Remember, the rights can be exercised at any time. Clients are to receive the best quality care without regard to race, creed, nationality, lifestyle choices, and diagnosis. Clients and family members always have the right to refuse care, and the client has the right to be safe. A few more things to remember. The client must be informed of care prior to the start of care services. The client has the right to be treated with respect, and the client has the right to make concerns and grievances known without fear. Client rights not only govern what the client may do and when, but how agency staff interacts with clients in their environment. Appropriate and professional interaction can increase confidence and overall client satisfaction. When you're in a client's home, always address the client using his or her name and appropriate title. Good morning, Mrs. Smith. Clients have the right to know who you are and what you're doing at all times. Treat the client's property with respect. Remember, although you're working, you are in somebody's home. Here are some more tips. Always introduce yourself. Always wear your name badge. Explain what you're doing prior to starting, and answer questions honestly. Clients have the right to make concerns known, and the agency has a responsibility to investigate the problem and resolve the issue to the client's satisfaction in a timely manner. From time to time, clients do get upset. If your client gets upset, it's important to remember to remain calm and objective and respond to questions and problems promptly. Don't take complaints personally and remain professional. Never yell or name call, don't make accusations, and don't accept or assign blame. For every right, there is a responsibility to assure that that right is exercised in a safe manner. As a healthcare provider, you have the responsibility to listen to your patient when they tell you what they need. Do not assume that you know what they need or want. Also, to explain what you're going to do with the patient prior to starting, in a language that's appropriate for his or her level of development and national origin. And be honest. If you don't know the answer to a question, redirect the question to the office. We are always available, and we're happy to help. Client privacy may be one of our most important client rights. Never eavesdrop or go through their personal belongings. What would we do without cell phones? But never use it to send or receive patient information. This could result in a serious HIPAA violation. A couple more reminders about patient privacy. Always secure documents with client information such as schedules and timesheets. Never hold conversations about clients in public. And don't gossip about clients or their family members. You can get a complete copy of the Patient Bill of Rights at the Osborne Home Care office. You're almost done. All that's left is to take the test. You'll find the link to the test on the YouTube.
Okay, so we didn't have a link to the test, and I know that that doesn't cross over completely to us, but I thought it had some great little informational tips there about not texting any patient information or gossiping and things like that. Of course, it did not apply to us, but like I said, I thought it had some really nice information there. What is the ADAA and the GINA Acts? The ADAA is the Americans with Disabilities Act, Amendments Act of 2008. On September 25th, 2008, the President signed the American with Disabilities Act, Amendments Act of 2008. The Act emphasizes that the definition of disability should be constructed in favor of broad coverage of individuals to the maximum extent permitted by the terms of the ADA, and generally shall not require extensive analysis. The Act makes important changes to the definition of the term disability by rejecting the holdings in several Supreme Court decisions and portions of the EEOC's and ADA regulation. The effect of these changes is to make it easier for individuals seeking protection under the ADA to establish that he or she has a disability within the meaning of the ADA. That's a lot of words, I know. What is the GINA Act? The Genetic Information Non-Discrimination Act of 2008 is a federal law that protects individuals from genetic discrimination in health insurance and employment. Genetic discrimination is the misuse of genetic information. So let's talk about HIPAA.
The Health Insurance Portability and Accountability Act, also known as HIPAA, was enacted in 1996. Since then, we've seen some major HIPAA violations that can cost up to $1.5 million per year. This can seem intimidating for your organization, especially if you don't know how to avoid a violation. Hi everyone, I'm Matt Moneypenny, and today I'm going to go over the 11 most common HIPAA violations. Your organization needs a better understanding of what you should and shouldn't do so that you don't face a breach.
Before diving deeper into this subject, make sure that you subscribe to our YouTube channel. Also, click on the alert bell icon so that you're notified when we post new helpful content.
Number 1, lack of employee training. Nearly a quarter of healthcare workers don't receive the proper HIPAA training that they need. But employee education and training can help your organization avoid all of the common violations on this list. Number 2, medical record mishandling. Using paper records increases the chance that protected health information, or PHI, will be left exposed for unauthorized people to see. Leaving computers unlocked also poses a risk. Locking your computers when not in use ensures protection of electronic records. Number 3, using insecure technology. As we use more digital health information, medical records are more susceptible to breaches. Using insecure technology to share PHI is a huge risk that should never be done because it will expose your organization to a breach. Number 4, hacking and malware. PHI records are worth 100 times as much as credit card numbers on the dark web, so hackers are intentionally seeking this information. It's so important to have antivirus, anti-malware, firewall software installed on your devices to help protect against hackers. Number 5, authorization and patient signature. Some employees will carelessly release PHI because they don't know what's required in order to release it in the first place. Uses and disclosures of PHI requires written consent by authorized individuals when it's not being used for treatment, healthcare operations, or payment. Number 6, disclosing the wrong patient's information. It's simple. Double check or even triple check that you are releasing the correct patient's information. Number 7, improper disposal of PHI. While people probably don't go through the garbage searching for PHI, it's definitely a best practice and recommended that you dispose of it properly through shredding, destroying, and hard drive wiping. Number 8, lost or stolen devices. Human error is uncontrollable, and you can't really prevent a stolen device from happening in the first place. Your organization must have the proper safeguards in place so that the PHI is not exposed from these stolen devices. Number 9, social media sharing. Using more social media increases the chances that a patient's photo will be shared on the internet. Employees must be cautious about what they post on social media, ensuring that it doesn't include anything regarding patients. Number 10, gossip and conversational breaches. Stories about patients may be fun and interesting, but discussing PHI is always off limits. This includes gossiping about patients to friends, family, or even coworkers. You never know who might be listening or what they might tell someone about. Number 11, celebrity file lookups. Not only can talking about patients be interesting, so can snooping into their files. This is very common with celebrities in particular, and even with no intention of sharing the information, it's still a breach if you look at files without authorization. Understanding these violations and the risk that they pose your organization will help you take the appropriate measures to prevent and avoid them. For more information on common HIPAA violations, reach out to eTactics. If you enjoyed the video, like it, share it, and comment.
Okay, so that was a lot on the HIPAA law. If you guys do not know about HIPAA, please take the time to look it up. Rachel and Angela, if you want to know, we're going to be teaching the HIPAA law all through. Poor Maria, Katrina, and Carmen probably don't want to hear anything else about the HIPAA law, but I think we all kind of pretty much know about that. The HITECH Act, or the Health Information Technology for Economic and Clinical Health Act, is part of an economic stimulus package introduced during the Obama administration. And the American Recovery and Reinvestment Act of 2009, the act was signed into law by President Barack Obama on February 17, 2009. The Affordable Care Act. The Comprehensive Health Care Reform Law enacted March 2010, sometimes known as ACA, PPACA, or Obamacare. And then it has the law has 3 primary goals, and those are the 3 goals. I'll let you read through those. And that is the end of this lecture. I know it was a lot of words and I kept getting tongue-tied. I'm so sorry, but this is not my favorite chapter. I love therapeutic communication because I love communication. I think it's so important. I do want to remind you that I'm going to be loading an informational page. It's a Google document of the healthcare, or the laws, the healthcare laws you're going to need to know, like the Stark Law, the truth in lending law, things like that that are going to be on your NCCT. And then I'm going to make sure to load a copy of that test at some point so that you can practice that. If you need anything, let me know. Bye.